Ready, start. The appellant is a sitting member of the Legislative Assembly from Firozpur Chirka constituency in Haryana and has been arraigned as one of the accused in FIR numbers 149 and 150, both dated 1/8/2023, registered at Police Station Nagina, District Nuh, in connection with large-scale communal violence that took place in the Nuh district on 31/7/2023. During the course of investigation, multiple individuals were named as accused and joint proceedings commenced before the trial court. However, by orders dated 28/8/2024 and 2/9/2024, the trial court directed the concerned station house officer to file a separate charge sheet against the appellant and consequently segregated his trial from that of the co-accused. Pursuant to the aforesaid directions, the police filed separate charge sheets against the appellant. Charges were framed on 25/11/2024 and the prosecution commenced evidence with some witnesses already examined. Aggrieved by the segregation of his trial, the appellant filed CRMM numbers 61515 and 61516 of 2024 before the High Court for quashing the aforesaid orders. However, by a common judgment dated 12/12/2024, the High Court dismissed both petitions and upheld the segregation. Assailing the impugned judgment, the learned senior counsel for the appellant submitted that the appellant, a sitting MLA, has been falsely implicated in the FIRs concerning the communal violence in Nuh district on 31/7/2023. The investigation itself revealed that the appellant was not present at the location of the incident and that there is no material evidence linking him to the alleged offences. Nevertheless, the relief sought herein is confined only to setting aside the segregation of his trial from that of the co-accused. It was contended that the trial court directed segregation of the appellant's trial solely on the ground that he is a sitting MLA, which reasoning is arbitrary, legally untenable, and amounts to a miscarriage of justice. Section 223 within bracket D CRPC provides that persons accused of the same offence committed in the course of the same transaction shall be tried jointly. Joint trials are the rule and separate trials are permissible only in exceptional circumstances expressly contemplated by law. In the present case, the alleged offences including rioting and conspiracy under section 120B IPC arise from the same issue, hence it is impermissible to try the alleged conspirator separately from the principal perpetrators. Learned senior counsel further submitted that the trial court placed reliance on the directions issued by this court in Ashwani Kumar Upadhyay versus Union of India to justify the segregation. However, those directions merely call for prioritization of trials involving MPs/MLAs for expeditious disposal and do not permit deviation from the statutory scheme nor authorize separate charge sheets or trials solely on the basis of accused's political status. It was further argued that the trial court exceeded its jurisdiction by directing the police to file a separate charge sheet as the discretion to file charge sheets lies exclusively with the investigating agency. Even when separate charge sheets are filed, if offences arise out of the same transaction, they must necessarily be tried jointly.